Before my brain explodes, I have to talk about the Van Zandt subpoena that I have been waiting for almost a year. We finally have the subpoena itself. We got drips and drabs over the course of the case, but we finally have the actual subpoena. So let me walk you through it. Long story short, it doesn't make me feel any better. It actually makes me feel worse to see everything as it is. Let me show you what I see when I'm looking at the document. So the first thing is, and this had been indicated to us in an article, but we couldn't test it, is that the date of this subpoena is October 1st of 2024. The Van Zandt case, the complaint was filed on September 27th of 2024. So they did not even bother to pretend that they were going to go out there and try to find out who the does were and serve them. They just went complaint filed, and if somebody looks up the calendar, it may have even been like a weekend in between. There is absolutely no even attempting we tried to look for the does for a couple of weeks and we couldn't find them. They filed the complaint. They got the summons issued. They didn't try to serve it anyone. They served the subpoena. Usually you do not start serving subpoenas until discovery opens, and usually discovery does not open until there's been an answer or a response to the complaint and the pleadings have been closed. So it's exactly what we thought it was. There's really no way for them to hide from the fact that it's exactly what what we thought it was. I'm not going to go after personally the woman who signed this. Obviously, I have a lot of questions. I'll probably never have the answers to those questions because of attorney-client privilege about why they agreed to do this. But what I find interesting here is that it says attorneys for plaintiff Van Zandt Inc. And what's fascinating about that is that when Van Zandt Inc. was actually deposed, when their 30B6 corporate rep was deposed in the main case, they sent a lawyer to testify, but it wasn't her. And that's interesting. Maybe they picked somebody other than her because she had personal knowledge about this, and the other person testified, I don't know anything about anything. Now, I have other thoughts about that I'll share with you later. But if she was, at the time, the attorney for Van Zandt Inc., and you wanted someone to testify on behalf of Van Zandt Inc. as its corporate rep who wasn't Ryan Reynolds, and you were going to have a lawyer do it, why wouldn't you have her do it? You know why? Because you don't want her to talk about this. Another thing that jumped off the page at me. This is to Stephanie Jones at JonesWorks, care of her attorneys. They sent this to Stephanie Jones's lawyers. So her lawyers at Quinn Emanuel, I don't know if it's the same lawyers that are doing her case now. It's the same firm, but it's a really big firm. They were part of this from this point on. They didn't send it to Stephanie Jones and she can be like, oh, I didn't ask a lawyer. I don't know. I just did it. Oh, sorry, my bad. I guess I should have asked. This went to lawyers. So the decision to turn over the documents in response to this didn't just come from Jones playing dumb. This came from her lawyers too. And when we get down to what the options were, to me, that has a lot of significance because even if Jones was like, oh, I don't really know about the confidentiality provisions, they sure as shit did. This is going to end up being 2 videos. There's terms in here that are very typical, like true and correct copies. These documents are material and necessary to the case. Things that are in your possession, custody, or control. Those are very typical things, cut and paste, that go in every subpoena. They do take on a little bit of a different meaning when you understand that the case that was filed, that this subpoena came out of, was a breach of contract case and had nothing to do with, at least by name, Lively, Reynolds, or any of those people. It does kind of make you question, are these really, these representations that you make in every single subpoena, were they actually true here? But it is pretty typical language. The definitions are interesting because the definitions identify and define a couple of things that there's no connection between those things and the complaint. Again, if you look at the Van Zandt complaint, it talks about how they think that somebody maybe breached a contract, but we don't really know who those people are, so they're does that had to do with reputation. But it doesn't say whose reputation, what contract, who, or how. But then the subpoena goes directly to the names. It goes to Lively, it goes to Reynolds. And then this definition of the Lively Reynolds companies is really interesting because it includes Aviation Gin and Mint Mobile. So I don't know what else might be in those documents from Stephanie Jones, from Jen Abel's phone that we haven't seen yet, but they made this far beyond the movie. They made this about, give us everything you have about these people and about any of the businesses that they run. And if you don't know which ones, it's all of these, including Maximum Effort. They then go on to define the film, which again, not mentioned in the complaint. The complaint and the subpoena look like they came out of two different cases, because the allegations in the complaint are so vague, and they're like, this is about reputation, but we're not going to say whose, and we're not going to say about what. And then you get into the subpoena and they go right to, it's about these people and these issues about this film during this time. So it just, again, confirms the fact that they filed the complaint the way that they did, first of all, for the sole purpose of putting this subpoena out. And second of all, they filed it vaguely on purpose so that none of us could find it and figure out what it was. But here's the part where my brain starts to break, because we actually get to see what they requested, what they subpoenaed, what the documents were that they were seeking. And they specifically ask for information regarding sexual harassment and retaliation. And they use those words. So remember, at this time, no case had been filed yet. No one had gone to the CRD or the federal courts and claimed sexual harassment or retaliation. But those are legal terms of art. Those, you all now know, those terms have very specific legal meanings. They did say, give us everything about like inappropriate conduct on set, but they actually used the term sexual harassment and retaliation. And why I think that is so important is that, beyond how would Stephanie Jones know that, but also because I believe this is the first time in the chronology that we actually see somebody on the Lively team use the term sexual harassment. I've been looking at all the evidence about what was raised on set, and they use the term HR claims, inappropriate behavior, but they aren't using this legal term of art, sexual harassment. Lindsay Strasberg does not use it. When she sends the 17-point list for the contract writer, she does not say sexual harassment. No one does. Even in the summer of 2024, when some of these little articles are starting to come out about tension on the set, it's more about abuse. He was abusive on set. He was difficult on set and abusive. This is the first time that I can remember that anybody representing Blake Lively used the word sexual harassment. So what that tells us is that by October 1st of 2024, her team was thinking about this as sexual harassment. Some lawyer had said to her, I think that's what this is or what it may be, and they were using that legal terminology as of October of 2024. And then it's just more of the same. So when Jones and her lawyers got this document, when they got this subpoena, they had a couple of options about what they could do, okay? Just based on what people would normally do when you get a subpoena like this. Number one is you could object to it. You could send objections back to the requester, and you could say, we object to this subpoena on a couple of grounds. The things that are just, easy right off the cuff are, this calls for a legal conclusion. I'm not going to determine what sexual harassment or retaliation are. Those are legal decisions that a court has to decide. So I can't possibly provide you documents based on the definition of those terms. Objection calls for a legal conclusion. They could also object and say responding to this may implicate confidential information, and I'm not sure if I can do that. I need you to file a motion to compel and get it in front of a judge so I can figure out if that information is confidential. And then just the most basic evidentiary objection in the world, discovery objection in the world, which is this isn't reasonably calculated to lead to the discovery of admissible evidence in this case, because you filed a case about a breach of contract and now you're asking me about sexual harassment. So option one would have been send objections and say, I've got some problems with this, and if you want this stuff from me, you're going to have to move to compel, and we'll fight it out in front of a judge. Go to the next one and I'll tell you the other two options.